Everyone, welcome to the Landlording Show. This is the show where we dive deep into property investing and not just how to invest in real estate, but what to do with it once you started your investing journey and have the properties. Today, I have a special guest from the law offices. I have Anthony V. Panzica. I've worked with Anthony since I've been in real estate, helping numerous family members, friends, all that close. And so I wanted to bring him on and talk about some pitfalls of closing. Whether you're on the buyer side or seller side, and then some things that you should be doing to save yourself some money and things like that after you close. So, let's start off with that and just sort of talk about when you're buying real estate. We call it an attorney review period. Sort of what is that and how does it work, and we'll go from there.
Yeah, for sure. So it's great points, Tim, because obviously a lot of times it's people's first time doing this, right? Or they're not too familiar with the process. So the contract is really set up to be pro buyer. There's a lot of contingencies in place. So that being the attorney review inspection provision being the most important one right off the bat. You're getting allowed 5 business days to check out the home, find out information from the seller side. Specifically on rental properties, we want to get as much tenant information as we can, right? So we kind of know what we're dealing with. But yeah, on the inspection side, you're just checking to make sure that everything came back okay. Maybe we need to ask for credits, maybe some repairs. So it's always like a good idea to get that completed within the time frames so you don't miss anything, because the attorneys are kind of have like our whole industry sometimes I feel is templates, right? So you'll kind of notice that we have like our set things we have to ask for. I have mine as well because I'm trying to put in things in place to protect the buyer so they don't walk into a big mess of potentially losing their earnest money, making sure the home appraises out. So there's certain parts I want to have in my letter and encompass any inspection items in there too, so we can be all on the same page of what we're asking for and what we're looking for.
So you brought up earnest money, and I want to talk on the buyer side and also I guess for the seller side too, because I think a lot of people put a lot of effort into earnest money, especially on the seller side, that they want to see X amount. And from a standpoint of, is the person financially okay and will they close? I get that. But how likely is it that you're going to lose earnest money, or what are some things that could cause you to lose earnest money if you don't follow these steps? I know you're speaking about timeline and things like that, but what are some things that you've seen?
Yeah, and that's a great thing to ask for too, because that happens all the time. Like if I'm representing the seller and the buyer's like not able to close, they're like, that's it, I'm keeping the earnest money. I'm like, well, it's not a unilateral decision, right? Like you need to have a document signed off on both buyer and seller that basically state earnest money is either returned, either is kept, is split. So you have to have both people agree. So even when we're in the wrong, like we did everything wrong, we blew the contingency, we didn't send any letters, we didn't ask for extension. The seller side still needs me to sign or my client to sign if I'm representing the buyer to agree to release those funds to the seller. Then sometimes if you think of it from that spot, if you just take a step back, not be so emotionally involved sometimes how people are getting, like, why would anyone sign a release form if they're losing all their money, right? Like, then just forget it. I'll just let it sit. So it's almost like you have to take that thought into it and be like, all right, well, I know I messed up, but like if it's, I'll split it or something, right? Like that's usually the more reasonable approach than being like, I'm keeping all this, or I'm not getting, it's like, it's probably not going to work. You're probably not getting any of it, right? Because you have to come to an agreement with the people. So it's either a court order or an agreement of the parties. It's the only way earnest money is moved.
How often do you, I won't age you and say how long you've been an attorney for, but how often in your experience have you seen earnest money on a failed deal? Like what percent do you think the earnest money doesn't go back to the buyer?
I mean, I'm in 16 years, so give me a little bit of time. I've seen a lot of transactions, done a lot of closings where the earnest money is not returned. Like we lose the money, even when we're like so wrong. I think maybe one time where we lost it all, right? But the client knowingly signed off on that because the seller side was threatening to sue, go to litigation. They already had the lawsuit filed. They were going to sue us for like 3 times the amount. And that attorney happened to be the litigation attorney. Those are the times the real estate attorneys possibly do it on the side. This guy was the litigation attorney that did real estate on the side. So he's like, I'm winning for sure. I'm like, oh, wow, I've never seen this before. So the client like willingly, they did everything wrong. They literally didn't show up the day of closing and knowingly breached. So that's one out of like thousands of transactions. Most common occurrences of funds go back to the buyer, almost always in full, if not a little bit of loss, even when they're in the wrong.
I I would agree, and I sort of set it up that way to what do they say? Only ask questions that you know the answer to when you're an attorney.
Yeah.
Um, but it is
Yeah.
very rare, and I think that's something that a lot of people will put a lot of emphasis on, or they think that they're scared to. If you're an investor buying, you're scared to go and if I have to put 5,000 down, what's going to happen if the inspection fails or things like that. And maybe other states are different, but Illinois is just such a buyer friendly state that you really can't rely on it as a seller, and you very rarely are going to lose it as a buyer. So, um,
Yeah, because that mortgage contingency too, to your point on that, like it says 45 days after acceptance or 5 business days before the closing date. So you could go all the way through 5 business days before loans denied or something happens with the financing, they're like, oh, earnest money's returned, right? So literally the only time it really happens is like when you just don't show up, like that one client that I suggested or mentioned, right? She just did like, ah, screw it. I don't feel I don't want it anymore. Like you change your mind like that. That's where you're supposed to have that risk of earnest money. But even still, you need both people to sign it. It just doesn't happen.
Absolutely. So let's pretend it was on the line. What are some dates that we should be looking forward, or in terms of if I'm a seller, this is a better way to put it because, like I said, earnest money is not too risky. If I'm a seller, what are some signs that the process is happening right? So generally speaking, it's 5 days for an inspection. After the inspection period, what are you looking for on the seller side to know that the buyer is actually moving forward? Um,
Like I want to get the letter from the attorney with that 5 business days too, right? Like, or they're asking me for an extension because the inspector was booked or whatever holiday, like they need more time. But usually we need to get that letter, and then that's a lot of tricky parts too, Tim, as well, because like sometimes people think, oh, it's 5 business days, it's up. It's like no, like someone sends a letter, then I actually have to have time to review it with the client, right? Get back to them. So then it's like 6 business days, 7 business days. Like it goes kind of back and forth until we have a sign off, right? So usually people are trying to make like not delay on purpose, but we're trying to get there. But let's say that resolves and we're good, right? We move on. Now it's like, okay, buyers got to be doing things with their loan. Like I want to see the lender requesting title changes, like change the mortgagee clause of this, show the loan amount as this. Like I need the title commitment in order to submit, right? Then they're going to be ordering their appraisal, right? So like you want to see language like that. You want to see updates like that. So the worst parts is when you get nothing. Like you don't hear about an appraisal, you don't see any title requests, and you're like, okay, is anyone home? Like, what's going on? Oh, we're switching lenders. Oh, we may be thinking of doing something else. We're getting different. We're talking. I'm like, but we've already passed like weeks. So you kind of got to stay on top of everyone just so you can find out what's happening.
Absolutely cool. Um, when you get the inspection report back, oftentimes I think the biggest question I get as a buyer's agent is do you prefer requesting repairs or prefer requesting credits? I'll let you answer, then I'll give my opinion too. But what's your opinion on that for your clients?
I think it's great. I think it's almost like kind of goes back and forth sometimes when I talk to different clients about it. My usual advice is like, sometimes the seller's out the door already, right? They're like, hey, I don't really want to be messing around with this. I'm not going to hire somebody. And then sometimes if they're hiring somebody, they're hiring somebody for the cheapest possible solution, right? Like just to fix it, to patch it, to get it done, just to close the piece us, but not maybe paying the extra money that it would be that you would if you were buying rather than your 1 foot out the door. So a lot of times I want to try to see if we could come up with numbers to get to the actual amounts and try to work that in as a credit so then we could possibly do it on our end as the buyer side, right? And actually put some maybe more care than the seller might.
I'd agree 100%. And a quick story: we had a client that came to us after we purchased the property for property management, and we took over, and they put in a brand new boiler, and it was he probably should have asked for a $20,000 clause. It was a big boiler credit, $20,000 credit. It was a big boiler, and he had them do it instead. Well, they put this boiler in, but they did not replace anything but the boiler, meaning that all the connections to the boiler, all the piping going up, all that stuff that
Yeah.
was corroded and 100 years old, they basically tried to tie it in. Well, you light the boiler up, and don't have pipes actually connected properly. All that stuff. It flooded. It broke down. He had to, he bought it in August, and in November he comes to us, and we're setting up the heat and everything, and already told him he needs a new boiler, and it was a big part of his attorney review period. So Yeah, I'm a big fan of the credits as well. Unless you know how to check it to make sure it was done right, or if you have someone that can check it before you close, and it's not always worth paying for another inspector and things like that. So it's often just better, in my opinion, just to have it taken care of.
And to that point too, Tim, as well, like their inspection, you paid like $400 or $500, right? Like they're not going to
Mhm.
follow you then at the walkthrough to do it unless you're like paying them again. So then it's like it's hard to sometimes get that out. You're not getting someone to check. Then what? A random buyer and you are there, and you're like, I don't know, is this right? Like it's hard to judge that. So
Yeah. What are you seeing? So one of the other things I'll see, and we'll get off AI after this, but a clause that I see a lot, that going back to EM not meaning anything, but the as is clause, at least in the Chicago
yes,
7.0 contract, or whatever number they are at now. I sort of think it's worthless, but I'm curious your opinion on it. And if you're a seller, should you give any weight to it? And if you're a buyer, how does it work in your mind as well? On
yeah,
that
I
side,
think it's a great question, and I've been on a couple other podcasts where the same conversation come up because like as is used to mean something. Like when you bought a foreclosure property or short sale, those were always as is, and everybody knew I'm not asking for anything. I can't ask for anything. This property is literally what that means. As is. I'm buying it. There's not going to do anything. It's now fast forward, all those time frames have passed. We don't really deal with many short sales and foreclosures like we used to at one point. So now as is kind of just like lost what it means, I feel like when I'm representing the seller, they think the buyer knows they're not going to ask for anything. But when I'm representing the buyer, the buyer's like, I know it's as is, but I didn't know there was going to be this and this, so now I have to ask for the credit. And then the sellers will come back and be like, but I told you it was as is. Okay, that being said, you guys asked for five, I'll give you 2,500. So then we have an agreement for 2,500. I'm like, this contract was as is, no credits, no credit, and yet we're giving a credit for $2,500. So it's like it's kind of lost its meaning that like people still ask, and you should, because now the sellers will actually come down to that level. So for both sides, it's like it's lost its meaning for it.
yeah. I also think another thing, and I haven't been in the industry long enough to really remember. I think I was couple years before the 7.0 came out, so I don't remember the old contract too well. But another misconception I get a lot is that as is waives the inspection, which is 100% not true. I think a lot of people think like, oh, well, it's as is. Why do you need an inspection? Because you're just going to buy it as is. Attorney review is still going to happen. The inspection is still going to happen. And like I said, I mean, there's so many times I've been on either side where, it's multiple offers and you give weight to that as is mark. And it just turns into, well, I did say as is, but we did the inspection and it was this bad. So it's either I walk away and you're left, without selling the house, or you want it again.
Yeah, and that's what that happens. And then the sellers kind of know, and then they're like, oh, now to your point, now am I going to go back and list it? Or I got this guy right here. What does he want? A couple $1,000 more? Okay, just give it to him, right? So that's why you said you have to still do the inspection, because you might find out something you didn't know, and then why not ask?
Yeah. What is if you're on the seller side, what's something that you see that you get requested, and not necessarily specific, but sort of maybe a guideline of like, when is a buyer being overreaching and just trying to mess with the seller versus reasonable? Like, is there a line of like level of things, or level of pre-knowledge before putting an offer, that you'll put your foot down and say, hey, well, you put an offer in, you obviously could see that before you put the offer.
Yeah, like they changed in the 7.0 to kind of guide us to big ticket items almost, right? Like roof, foundation, furnace, and boilers, HVAC. It's like they're like, look at those things. Don't look at the door and handle squeaky and it's like got to be replaced. It's like, okay, like that's like kind of a given. So when you get a buyer that's like, and I've represented buyers like this, and it's like, I want this, this, and this, and like they pretty much just send them the whole inspection report. I'm like, well, number one, we're not supposed to do that. It says literally in the contract, do not send the whole inspection report unless requested. But I'm like, we can't be asking for like the door handle squeaky, like repair it, like focus on the big stuff. So I try to guide buyers to that like direction. But I've had to, unfortunately, sometimes send it, because if the client's demanding me to do it, I have to do it, right? But then the seller side is just going to get frustrated if they see a request for like 45 things. It's like probably should have focused in on the 4 main ones rather than the 46 that the inspector wrote because he's trying to get his job and show that he like did some stuff, you know?
Yeah, yeah.
So I mean, you've seen inspection reports as well, and you kind of know like you're not supposed to ask just because they write it down. Don't ask for it, right? Focus on the big items. I think is kind of the idea.
Why do you think they did that at car, or at, I guess it is a car, the 7.0's car? Took away the sending over of the inspection reports. I know in the old days they would just here's the entire inspection report. What was the process of getting rid of that, or why did they?
Yeah, disclosure reasons, right? Because as soon as you know, you have to disclose. So a lot of the times it was like, well, I didn't know this. Right now, the buyer's bringing it to your attention. Right now, on your next potential case, you're supposed to disclose that to all buyers, right? So that's kind of, I feel like, the main reason they were doing that. So the sellers are supposed to disclose the information they provide in the report.
Let's go backwards really quick, just as you brought that up. So disclosures. I think the best way to say it, and if you want to add anything to it, but it's basically you're not disclosing what's wrong with the property. You're disclosing what you know is wrong. So just because a seller signs off on a disclosure, they might not have been to the property in 5 years. They might not have any idea, and they're still legally doing what they're supposed to. So at what point does it cross that line? Like if I had a sewer backup and a plumber came out and fixed it, do I have to disclose that at all? Or like, where does that line of there's a problem versus it was fixed, I don't have to disclose it go?
Yeah, I think it's always when in doubt, disclose is probably the better way to handle it, right? Like even if you say that, like I had a sewer backup problem, I had it repaired in 2020, right? And there's been no issues since. They give you that little section underneath all the questions, right, where you can kind of write something like that. Because I sold my personal home, we never had water and ever. Our home was power washed and the water came in through like seepage on the bottom, but rain doesn't hit like 100 miles an hour coming from the bottom. So I disclosed that. And then it was like, I felt it was better to say that than not say that, right? So it was kind of my thought process. So the disclosure in itself, just kind of a little takeaway from that part. I work with some attorneys that have to file litigation. Not that these are good topics, but like it happens, like the seller didn't disclose, and now all these things are popping up, and it's like, when I work with the attorney that do litigation matters, they're always like, Anthony, I want to see the contract, but I really want to see the residential disclosure. I'm like, oh, the thing everyone just checks no on? He's like, yeah, that thing. Because he's like, that is actually what you can get the seller on for failure to disclose. So when in doubt, disclose all, right? Because if it ever gets to that point and you're going to get sued, if it's not there, that's what litigation attorneys want to see, that document.
Last thing on attorney review, and then we'll move on from there. But I know one thing that a lot of attorneys ask, and I know you do too, is like past insurance claims. And then, I'm trying to think of other things that you guys ask for. But along that line, one, why do you ask for past insurance claims, and what effect does that have on the buyer? And two, what are some other similar things that you might ask for during AI if you're a buyer?
Yeah, that's in my like template one. It's a lot of attorneys' templates one. You're trying to find out information that like would help make a buyer decision to know like if there's an insurance claim on the home. Like I had a client, this just happened the other day. They had an insurance claim on the property. It was like $30,000. We asked to see some more details. It just provided the statement from the insurance company that said $30,000 insurance. I'm like, no, but what happened? So it's like, oh, here's the whole thing. It's like it was all repaired, it was all fixed, everything was good, but it's like you're supposed to know that, right? Like you're supposed to another thing to disclose to the buyers. So it gets us back to the notion that you're to disclose this information to the buyers. So we ask for that so we can find out more information from the home. The other one that's kind of like the most simplest that I have to ask for, and I feel like this is now almost every attorney letter has it, like it's stunningly not in the contract, like the appraised value of the home, right? Like if you type in, just open up a 7.0 contract, like type in appraised, like it doesn't come up there. So like if the property doesn't appraise out, like the buyer's not going to be forced to purchase it. So I have to put that in all the letters because like if we make an offer for 400, it appraises at like, 380, like we're not going to be paying the 400 anymore. We would want the price to be brought down to the 380. So it's almost like you're trying to put that in there. So you're leading that to that conversation. We're not just going to close at 400 if it appraises a lot.
Let's we close AI, during the transaction. Let's move on a little bit. We're getting closer to closing. Proration of taxes. What are some key points on there, and how are you guys as attorneys sort of calculating it, and it's a very hard thing because taxes we pay taxes in arrears. So this year we're paying last year's taxes, but when we're closing, we have no idea what that price is going to be. So how do you guys work that out?
Yeah, great point. So while in attorney review, one of the other things I have checked for is to go specifically for Cook County properties. Everything's public record. Cook County does this triannual assessment. So it really depends on where your client is purchasing or where the property is located to determine if we're going to be in a reassessment year. So like this past year, we all just got our second installment tax bills, but everyone who was in the central and southern parts of Cook County just got hit with a really large increase because this was their new year of the last triennial assessment. So the last time they were reassessed was 2020. So now we're looking at 2023 there, this year being a reassessment year. So all the contracts that I had in, let's say, Oak Lawn, Orland Park, or anything like this, before the second installment came out, I had to go to the office for the assessors, see what that increased value was, and then ask for the taxes to be prorated on that new increased value. It sounds like, what a waste, why am I even bothering? But like, if the value is showing 100 and now the value shows 200, and the taxes are currently 5,000, that's doubling the value. That potentially puts the taxes at $10,000 a year. So it's like a big jump. So it's like you have to then ask for the proper tax credit to be provided to the client, so they're not stuck. They're going to be stuck with a big bill when it comes out anyways, but like we need to make sure they're at least getting credited because, as you mentioned, Tim, the taxes are paid in arrears. We're going to be paying 2023's bill. We didn't even own the home in 23. So it's like at least get the right credit. So when I'm on the buyer side, I'm asking for the larger credit to be given. But probably the more fair way to do it is we're on the side, like I want to hold the money back, right? Because let's see what the bill comes out at. Maybe it not necessarily goes from 5 to 10, maybe it goes from 5 to 8. But we're trying to make sure that both parties are protected and made whole in this case.
So you're talking about holding back. So you're saying instead of, hey, we can't come to an agreement because we don't know what this fictitious number is going to be yet. So you're saying, hey, it might be between $2,000 and $10,000. Let's hold $10,000 back, and then it can go to the seller or the buyer depending on the split of the tax bill.
Yeah, and then when the second installment comes out, like it just came out, so a lot of attorneys are doing the calculations and the math. I'm still doing some myself, but like now it's like, hey, the bill is out. We need to prorate those figures back. So it's probably the most fair to hold money back because there's a lot of other calculators. I don't want to get too technical, but there's like state equalizers and multipliers, right? Mm-hmm. Like those things change every year. So just because I see the assessed value go from 100 to 200, it doesn't necessarily mean this $5,000 bill goes to 10. Like I just had this example, and the bill went from to like 7,500. So if I was the buyer, I would have gotten a larger tax credit in my closing, but that would have been a windfall for my buyer because he was getting taxes based on a $10,000 value. It's not right. The bill only came to 75. So if we would have held $5,000, we could have properly done this where 25 went to the buyer, 25 went to the seller, and we would have been like more fair, I guess, to the case.
Well, so speaking on taxes, and we'll jump back in a second, but I just want to go to after closing or things like that. But what are some things that after you close that you should be looking at in terms of tax credits and making sure that your taxes aren't getting raised, whether it be from a exemption or just challenging taxes, things like that?
Yeah, of course. So like that assessed value is kind of like your starter kit. Like you're looking for a home, you should check the assessor's office on all of them. When you're checking the assessor's office, you'll see exemptions because sometimes you're buying from a person that's a senior and they have a senior freeze discount, right? Or they have a veteran discount. It makes the tax bills extremely low. So if you're not too familiar with it, you might just tell the client like, oh, the taxes on this home are only $3,000, not realizing a senior freeze has reduced the taxes from 8,000 to 3,000, right? So it's like the real bill, your client's not 65, they're not going to qualify. So you got to kind of keep that in your mind too. But then going forward, the buyer's to apply for that homeowner's exemption the following year. And that's where a lot of people get mixed up because Cook County actually, they don't send any notices out. They make more money if they don't remind us to file for that homeowner's exemption. So it's kind of like a thing to do to like, as a great tool to like, just go check, right? Like I've been trying to run this as like a thing, like honestly, go to cookcountypropertyinfo.com. Type in your friend's address, type in your mom's address, dad's address, family members. Like, just double check that people are getting their homeowner's exemption. You'd be surprised how many people aren't. Like me and you take it for granted. Like, yeah, we get our exemptions, but like, this is our world. This is our field. Our buddy we know our whole life, they don't know, right? Like, our client has closed one transaction ever. They don't remember in a year from now, I got to go back to this random website, fill out this form. So it's kind of like a good way to stay in touch with the clients. and also just kind of be nice person, like help people out, remind them to file for these forms.
So there's homeowners, there's senior, and what's the difference between senior exemption and senior freeze? I know that's two of
Yeah,
them.
great question. So the senior exemption is just 65. The homeowners, you just live there. So those are just like straightforward. Once you file, you're in. You don't have to do any refiling. You're just good with the county, right? The senior freeze is income under $65,000 a year and over 65. So it's an income requirement too. So they usually want that one to be applied for yearly. And a lot of times some people might miss that or forget that. So that's like a one that you have to do. And same with the veteran discount. If you are any disabilities, depending on the level of your disability, that could be a really big savings, like potentially wiping out the entire tax bill. So veterans usually know about this, but sometimes when you're on the buy side of purchasing home from a veteran, you need to make sure the veteran is going to make sure he fills out the papers, she fills out the paperwork next year to sustain that one more year for you.
What are the requirements as a veteran to get the discount?
They have some disability. Yeah, it's not like you were a veteran and you get a discount. It should be, but it's not. It's more like the disabled veteran status. Like, how much of a disability do you have? So medically, they got to get some doctor notices and clearances to show that. And if it's like 70% or greater, it's almost wiping out the entire tax bill. So I've had some cases where we're closing and the bill's zero, and it's been zero for years, and it was like, oh yeah, I got the discount here for the disability veteran status. And I'm like, wow. So what we have to do, because the buyer's like, well, how am I going to know you're going to fill out this form next year? So we have to hold back that 8,000 or 9,000, whatever it is. So when the next year comes about, my client fills out the form, so the bill comes around, the exemption still stays. So on that buy side, it's really tricky to make sure, or very important to make sure that you get that fund somebody held back at your closing.
Cool. And I guess just make sure we're listing them all: homeowners, senior freeze, disabled veterans. Is there any other ones that we're missing? That's the four main ones, I think, right?
They got like a long time homeowner exemption, right? So it's just on their website. It's almost like if you've hit a certain period of time, they may give you an increased discount on your property taxes, but it's kind of just like part of the process. But it's the senior, the freeze, the veteran. There's a returning veteran one. So like if you were stationed somewhere for that year and you're not going to be in the property, now you come back, right? They'll give you a 1-year discount for like a returning veteran, right? Just from active duty. But those are kind of the main ones, usually the homeowner and senior.
Coming back, one more topic I want to hit on before we head out, but looking at things again, we talk about taxes. The other thing for a lot of our clients being investors is rent, and I guess a two-part question: when you have tenants in a property that someone's purchasing, is there anything actually that you're asking for? And then the second part is at closing, how do we prorate it?
Yeah, great stuff. So sometimes the properties you're buying, investment buildings, the properties are already under like the Chicago Housing Authority, like Section 8 tenants, right? And that is really tricky for someone who's not too familiar with it. There is a lot of paperwork you have to fill out. So at closing, before closing, I'm asking for like a voucher number that person has, because we have to transfer that over, and CHA takes a while to process a request. So if you're not familiar with it, or this is your first time buying it, it's like you have to get all those documentation in, which is a lot of paperwork, just filling out your info, your routing info, right? They're going to wire you these funds. So it's a really nice program to have. But like if you're slacking on that or going on that, they automatically pay that every month. And if you close to the end of the month, you might be shortchanging your clients some funds if they're not like filling out the funds or having the seller hold some funds back. So it's a little like unique situation to the scenarios. But if it's just your regular tenants, we won't try to get a rent roll in advance. We want to maybe get estoppel certificates or letters that the sellers are having the tenants complete to show the buyer, these are my rents, these are my deposits. And then at closing, we're asking for a tenant letter. So that's now the seller stating like, hey, unit 1 pays $1,000, the deposit's $1,000, here's a letter, give it to the tenant. And then I need an assignment of rents too. So like if I have to ever evict one of these tenants I didn't place, now I have a piece of paper that says I could step into the shoes of the prior owner and evict this tenant. So there's a lot of documentation that's I need to obtain and then to show the client. And then at closing on your proration amount, just depends when we close. If it's $1,000 a month, halfway through the month, like they would give us a credit for $500, as well as to give us the credit for the deposit if any. So those things all got to be verified and calculated and checked, because guess what? Attorneys make mistakes sometimes in the proration. So you always have to verify at closing one last time.
Yeah, I just had the client come to us, and luckily the client they're the buyer, so not in there, but the seller reached out 2 weeks after closing, and they miscalculated it, and they were asking for money back. At that point, it's too late. But so you want to make sure that you're double checking everything, make sure things don't
Yeah.
change on you. Have you seen people? Because it's an idea I had, but I don't know how common it is. CHA specifically is very bad at stopping payments and switching over. And if you close July 25th, August's rent's going to the current owner. Like they're not going to get there that quick.
100%. Yeah.
So, are you prorating that in, just knowing that's a fact, or doing a holdback, or how are you taking care of that?
Like just to play the game, like they're not just going to give us the funds, so we will hold back because there's always I guess there's a chance CHA move quickly, even though we all know that's not happening, right? So, but we're still having the seller side hold back that entire month's rent. So then when it does hit their account, then they could just send the check to the buyer for that difference. And then again, I'm trying to have that whole paperwork. It's like an 18-page packet or something like this. Like at closing, I'm trying to have the buyer complete as much as we can. So I can be like, buyer, just literally from this point on now, you have to get this to CHA as quick as possible because I'm more concerned now we close on the 25th. Are they going to make the next month's? If they sit on it, we're risking now maybe not getting that one either. So they got to move quick.
Absolutely. They have, for whatever reason, it's been the last year. It used to be about a 30-day to do a COM or change of ownership with them, and it's been 60, 90 consistently for since the end of last summer. So I don't know what's going on over there, but it's been a lot slower. The other thing I want to mention that just came up, but I don't know the case law or the exact case, but I know I read about it, that basically someone was evicting and trying to demand the past payments. And the judge ruled that there was no assignment of lease of the past due rents. So it's something that I guess the paperwork wasn't filled out or however it goes, but there was, hey, the tenant owed $5,000 before you closed, and they sued for that and tried to get the eviction off that. And basically the judge threw it out just due to the previous owner would have had to do that eviction, not you.
Yeah, it makes sense.
So assignment of past rents assignment. So yeah.
Yeah, like that past guy was entitled to the funds. You're taking over from this day going forward, right? So it's always like you want to get everything you can for that time frame, right? Like even if the guy's in default, I have a closing tomorrow where one of the tenants is delinquent, but they're still giving us the rent credits because they're like, we'll deal with that collection part on your own. Because I'm like, don't make my client be a chaser and now going to go hound this tenant for the month rent. I told the attorney, I'm like, you give us the credits. If you get the funds, that's on your guy. Like you still are entitled to give us the rent funds. He's like, well, I didn't get paid. I'm like, so what? So they have to give us the credit. There's like 6-unit buildings, so we're getting 6 rents, even though only 5 people pay.
That's a good point. So it doesn't. Yeah, I mean, obviously everything's negotiable, but that's a good idea. It doesn't matter if you weren't able to collect. That's on you. Still get the credit. And then for my clients that are starting evictions, and we do this with new clients too, because a lot of times it's a management company that didn't keep good records or whatever. I can't, like, if you come to me and sign up today, we're taping this on July 18th. I'm not going to evict on July 1st money that you don't have. We're going to wait till August 1st and serve the 5-day, and it will just be on August 1st money. We know they're not going to pay. If they haven't paid for 5 months, they're not going to magically pay August 1st. So we'll start the eviction on that, and it's a cleaner slate and cleaner to go to the judge, because the judge will, on eviction court, it happens way too often when you get 8 months in and the judge throws it out and you got to start over. So whatever the cleanest, less cannot be argued way to do it is the way. Cool. Awesome,
on that point, Tim, do you guys actually serve the notices yourself for your company? Like if the clients hire
we
you,
do. We serve we'll serve the 5-day notices for our clients, and then after the 5 days, if we can't negotiate cash for keys or another payment plan or something like that with a tenant, then we'll pass forward to an attorney to file the eviction in court and go from there. So,
do you feel like the 5 days ever works where they get back on their feet? Or is it more rare where it's like it's just leading to the demise?
Does. I mean, we have, so again, we're with Southside, so mostly C and D class properties. So someone being 5 days late is not uncommon. Unfortunately, it's just the world that we live in. If something, if they twist their ankle, they take a day off of work, they don't have enough money to pay rent and food. It's just where we are. So we actually have systems where we will falsely, and when I say falsely, I mean improperly serve a 5-day notice. Hopefully no tenants listen to this, but it's a lot faster to email a 5-day notice or tape it to their door, slide it onto their door. We know we can't follow that, and we're not trying to. But we want them to call us and conversate with us and say, "Oh, I got this. Let me do something."
Try to work it out. Yeah.
Yeah. But then after the 30-day period, then we'll, if they're late more than 30 days, then we're actually serving them properly the 5-day notice. And sometimes generally, if it gets to that point, generally, unless there's a real story behind it, someone got into a car accident, someone lost their job, and they're working for a new one, it's not that recoverable. So we'll try to do cash for keys. But a lot of times, that 2 weeks late or a month late, we'll get tenants that call us and say, "Hey, this is what happened. I lost my job. I have a new one, but I'm going to be behind." And instead of saying, "Cool, you need to pay us 2 months on the 1st of August," we'll work it out to say, "All right, cool. You owe us $1,000 for July. You're having a shitty time. Pay us $1,200 for August and $1,200 going forward until that $1,000's up." And it keeps them from going in a bigger hole that they can't dig out of by keeping it reasonable and saying, "All right, you're just going to put a couple $100 extra each month reasonably, and you'll get back on your feet in 6 months." Whereas when you put someone behind 2 months, it's the mentality, I think, sometimes of, "I don't have $2,000. I can't pay that, so I'm going to let it go 3 months. Then I really don't have $3,000." And, they're not going to chip away because they don't see the light at the end of the tunnel. Yeah. So they don't even chip away, and they just go and, spend their money doing other things. So that's how we see it.
Okay. That's good to know, because sometimes I only see this side of it. I don't really ever see like that side of it. So it's interesting to see. So
absolutely. Absolutely. Anthony, man, thank you. I'm going to wrap up. Thank you so much for coming on. Great content for everyone. I hope everyone enjoyed it. And we'll catch you guys next time.